Thanks to everybody for coming back in this morning, and thanks to Mike and everybody for putting this event on. So our first panel today, Will Bode and Steve Sachs are going to present their paper, The Law of Interpretation. I believe Steve is going to do the presenting. So 10 minutes.
Thank you. Thank you all very much to Mike and Mike, the organizers, for having us, and to all of you for coming and listening and hopefully reading the paper. This paper is very much in draft. We are very eager to hear suggestions for its revision. Engages with the work of a number of people here. We apologize in advance for accidentally misrepresenting any of your work. If so, please tell us. Any errors are Will's fault. This paper discusses the law of interpretation. It makes the claim that interpretation is an activity subject to law, an activity governed by law. It is not merely the question of how best to read a legal instrument, a legal text, according to some natural language that's actually spoken by actual people. Rather, the legal content of legal instruments is determined by the combination of those things with legal rules that specify what kind of meaning we're looking for, what kind of interpretive conventions we're going to apply, and in some cases supplant what would otherwise be the natural interpretation. This is relatively well known in the context of private law, but we argue that it also extends to statutes and indeed to the US Constitution. This fact hasn't been widely appreciated yet, in part because of a sense that if legal rules of interpretation are going to, in some ways, alter the legal output of a text, they must outrank that text. They must come from a higher source of law. So statutes might be governed by the Constitution might be governed by the intergalactic Constitution, but if we don't have anything like that, then there's no place to look for legal rules. Our claim is that that's not true, that a legal interpretive rule doesn't have to outrank the material that it interprets, and that many of these legal interpretive rules are in fact found in unwritten law. We believe that this view helps explain what's going on in a number of areas of contest in the Academy right now, including the status and validity of the canons, the legitimacy and scope of the activity of construction, and indeed many questions at the core of originalism. So in the time that remains, which is not very much, I'll try, probably without too much success, to summarize the argument of the paper. The foil of the paper is in some sense something we call the standard picture, which many people may not think they partake of, but we think is in fact quite widespread. It's the view that the legal effect of a legal instrument is determined primarily, almost exclusively, by the meaning of its language on some appropriate theory of meaning. We're looking for the actual intentions, beliefs, purposes of actual people according to some natural language they speak. They were the ones who chose what to put in the law, so we should see what the thing they said means according to the right theory of meaning. And once we're done figuring out that communicative content, we know sort of the core of the legal content of that instrument having been adopted. This view has, we think, two problems. The first is it doesn't seem to match what legal interpreters actually do. When you look at courts, they're consulting all sorts of weird rules and canons about, land grants and Indian tribes and series qualifiers and things that may or may not line up with actual usage by actual people. The drafters in Congress, according to a recent empirical literature, may or may not know of any of these things. They may not like them particularly. They apply statutes hidden in the code that no one's heard about, like the 108 repeal revival rule that extremely few lawyers know exists. And this seems odd if the activity that's really going on is attempting to capture some sort of actual theory of meaning according to the intentions of the drafters, according to the understanding of a general public, according to purposes, and so on and so forth. The second problem is that there are indeed multiple ways of reading a text and multiple theories of ordinary meaning. You can rely on the author's intentions, you can rely on public understandings, and so on and so forth. None of these is automatically endorsed by the law. You could imagine that different legal systems would choose different ones for different purposes, and that fact makes it very hard to insist that any one of them simply must be the font of legal content of a legal instrument. This has led to responses by scholars that we describe as the skeptics, though they may or may not accept that label, and saying that, look, because there are lots of theories of meaning out there, you have to be able to choose among them on what they think will be primarily non-legal grounds. So they're normative grounds in sort of case-by-case decision-making, or normative grounds in the context of what makes the interpretive process overall better rather than worse. Our claim is that, as in other areas, these normative disputes are often and to a large extent settled by pre-existing rules of law. In private law, you have the examples of the Peerless case or the UCC zero quantity rule. There are rules that are imposed that might or might not track ordinary senses of meaning like a party's expectations and so on, but maybe they're just there to make the system work better. Maybe they're there to serve social goals that have nothing to do with the underlying meaning, if any, of a particular instrument. Indeed, they might choose the theory of meaning that applies in a case-by-case way, and one can get that from the law rather than from non-legal normative choice. Our claim is that that occurs in public law as well. And we go through, and the core of the paper is describing how this happens without necessarily outranking the source of the public law or tying the author's hands. If you look at statutes, it's commonplace that a new criminal statute will be defeated in certain instances by statutory defenses or exclusions elsewhere in the code that the authors and readers of the statute might be totally ignorant of at the time that the statute is passed. And that happens even though the new statute outranks the old, and even though if it really contradicted the two in a way that sort of by express or fair implication would impliedly repeal the old statute, the new statute would win. Nonetheless, we understand, in Bentham's words, that every new enactment is like water poured into the sea. It takes place in a world already stuffed full of legal rules, and so has to be understood from the legal system's perspective, not necessarily from any individual reader's perspective, as an output of those legal rules applied to this particular text in the circumstances. We argue that this occurs for unwritten rules as well as for existing statutes because they don't need to outrank. It can come from any source within the law, and we give various examples both of substantive unwritten defenses and interpretive rules, default rules such as mens rea, priority rules like the last-in-time rule, closure rules like the land-grant canon, and all sorts of ways in which unwritten law affects the legal content of a new instrument. We also argue that unwritten law can affect the very fundament of the activity of interpretation. It can tell you what the object of interpretation is, whether legislative history is part of the enactment or just like a drafter's napkin that's sort of, a product of the process, not the actual thing. What role the new enactment has, whether it's advisory or whether it's binding, and which interpretive approach to apply in various circumstances. Whether we use textualism or purpose or other things could be a matter subject to unwritten law. This is something that can affect not only statutes but also the U.S. Constitution. We give the example of the 21st Amendment and the prosecutory abatement rule, an example suggested to us by John Harrison, that shows that we do in fact use legal rules of interpretation to understand the Constitution, often ones from sources such as unwritten law that are wildly outranked by the constitutional text itself. We identify two implications of this view. The first is it helps us understand what's going on with the canons. There's been a great deal, as I said, of empirical literature about the canons. Many of them are not in fact known of by the drafters. We think that whether that argument affects the status of the canons depends in large part on what kind of canons we're working with. Are these linguistic rules that are really just heuristics, habits of mind, trying to figure out what the drafters, original readers, etc. had in mind? Or are they legal rules that operate in a binding way, notwithstanding any of those things unless they are impliedly repealed? In the latter case, it doesn't matter whether the drafters knew about them or not. The statute is poured like water into the sea. It falls into the existing law, and the existing law helps determine its legal content. The second thing we think this helps understand is the scope and nature of the activity of construction, something that's debated a great deal around these tables. We think that construction is a real thing. There is a distinction between trying to figure out the natural language meaning of a particular written text and its legal content. We think the law of interpretation helps explain how construction legally ought to work in our particular system and reduces some of the perceived loosey-goosiness that has led to opposition to the nature of construction or the argument that it would apply. Finally, and because of the nature of this conference, I want to close with a few thoughts on what this means for originalism. If you make some additional assumptions, which the two of us do, that legal instruments primarily do their legal work at the time of their adoption, and that whatever legal content they contribute to the law stays put until changed, then this immediately directs you to the original legal rules that govern the legal content of these instruments, what the adoption rules were that fixed their content at the time of adoption, and so suggest that in the end what we're looking for is original legal content of these rules as opposed to legal content under some other set of legal rules that might be applied today. I'll stop there for reasons of time. We very much look forward to your questions, and thank you again for giving us the opportunity.